Okay, let's go ahead and get started. Thank you for joining us for Hello Divorce's webinar, the 10 common divorce mistakes that you need to avoid. I am Erin Levine. I'm the co-founder of Hello Divorce and a certified family law specialist. What to expect today in our webinar is an understanding of the common pitfalls self-represented people have succumbed to and how to avoid them in your divorce. So whether you are supporting someone through a divorce, or you are thinking about filing, or you're actually in the throes of the divorce itself, I expect that this webinar will be very helpful for you. The first mistake I want you to avoid in divorce is focusing on the substance instead of the procedure. Like I mentioned earlier, the procedure for divorce is quite complicated. There are lots of forms and lots of steps. And it's really important to pay attention to each one. If you follow along with our navigator, you'll really be able to do that. Let me give you an example of why it's so important to follow procedure. So there's this common misconception that if your spouse files a petition, you don't need to file a response. And the reason is, if you have an amicable divorce, a lot of people believe that why would I need to file a response? So there are only two scenarios where a response should not be filed. One scenario is if the two of you are in mediation with a certified mediator, either through Hello Divorce or on your own, and you've agreed in writing, an email is sufficient, that the petitioner will give you extra time to file a response. Instead of the normal 30 days, you'll get 60 or 90 days while you try to work out an agreement. If that's the case, you can hold off on filing a response. The second time you can hold off is if you already have a complete agreement, usually called a marital settlement agreement, that details all of the issues in your divorce. So your property, your debt, if support will be paid and for how much and how long, and if you have kids, a parenting plan. If you already have an agreement and it's been signed and notarized, then you can avoid filing response. Otherwise, I think it's a really good and important idea to file a response, because if you don't, you lose leverage. What I mean by that is that the petitioner, the spouse that files for divorce, can take your default. And what that means is that you can't respond to the action. If things get messy, your spouse has all the leverage and can ask the court for whatever orders they want within reason, but really whatever orders they want. And so by failing to file a response, you could really lose leverage in your case. Okay, a couple quick tips. The first one in this webinar is that you have 30 days to file a response. So there's two ways you can be served with a petition in divorce. One is by somebody personally serving you, not your spouse, but a third party. The other is by the petition being mailed to you and you sign what's called a notice and acknowledgement of receipt. Either way, whether you're served or you sign, you have 30 days to file that response. If for whatever reason you didn't file a response because you didn't know and your spouse has taken a default, you may be able to get that default set aside, and then you can participate in the divorce itself. The way that you do that is by following step 2 in our divorce navigator. That's filing a request for order. You can follow our divorce navigator, or you can contact us and we'll coach you through it or prepare it for you. But we think it's a really good and important idea. So another example of why it's so important to follow a process is if you're what's called the out spouse. And what I mean by that is if you're the spouse who doesn't have access to a lot of the financial documents that you need in order to make good decisions for yourself in the divorce. And there are actually plenty of processes by which you can go that will help you get the documents you need. And so if you're aware of the process, if you follow the navigator, then you can get these documents. If you don't, you end up waiving your right to receive these documents, and then you really don't have the knowledge that you need to be able to get them. So the process by which you get these documents is called discovery, and there are lots of different methods and ways to do it. Don't let these words overwhelm you. We have instructions for doing it, and so if you end up needing it, you can log on and we'll help you through it. And the last example for why it's so important to follow the process is that if you have a court hearing and you don't get your documents in on time, you risk two things. You risk the judge not reading them, and then you don't have a say, or the other side, your spouse or your spouse's attorney, objecting to you presenting testimony, presenting your position. So it's really important to follow process when you do your California divorce. You may also want to check the California court website to see if there are additional procedures or forms that are specific to your jurisdiction, or you can talk to us and we'll help you figure that out. We have a resource with all the websites to every county court in the state, and you're welcome to take a look at that too. You may also want to take a look at our glossary of terms. You can find that in the footer of hellodivorce.com. And what this does is takes all the legalese and boils it down into layman's terms. So it makes it a whole lot easier to understand the divorce process, and you'll feel a lot less overwhelmed. And in that same vein of following process, make sure you pay attention to our service of process rules. That's when you get served with documents and how you serve your own documents on your spouse, even in an uncontested divorce. Okay, we'll move through a lot of these other mistakes quicker. The second mistake to avoid is failing to schedule a legal coaching session to strategize your case. So when you sign up for Hello Divorce, you get a free 15-minute session with me or another lawyer at Hello Divorce. I highly recommend you take us up on it. It might be just to ask us a few burning legal questions that you have, or we can help you develop a plan. Sometimes that's enough. If you have a divorce without any kids and limited access, that 15 minutes might be enough. But if you have a more complex divorce or some issues that you aren't quite sure about, then I highly recommend you sign up for a 30-minute or 1-hour session either with us or with a divorce attorney of your choice. Don't assume that what you've read on the internet is accurate. I know you know that, but I want to remind you that a lot of the information you receive online is not written by lawyers or not written by certified family law specialists like us. It's really important that you get good information that you can trust. Hello Divorce has information that we're cross-checking all the time to make sure that it's accurate and up to date. You can also go to the California court website. They have some great information. And if you're concerned about child support, you can go to Hello Divorce, or you can go to the Department of Child Support Services. They will also have accurate and up-to-date information. Always make sure that if you're consulting with a lawyer, you get one with a strong reputation. And some of the things that you can cover when talking with a lawyer are issues that you may not have considered, your rights. So even if you have an uncontested divorce, you still don't want to give away the farm. You still want to know where you might have some financial exposure and where you can maximize your financial gain. It might mean that you decide to be a little bit more generous, and if that's the case, great, but at least you know where to start from. So we think it's a good idea for you to learn your rights. How to minimize financial exposure is also important. Whether or not it's cost effective to go to court. in some situations, I might tell you, hey, look it's going to cost you $500 to go to court, but you stand to gain $5,000. In other situations, I might tell you, hey, it's going to cost you $2,000 to go to court, and really your best case scenario is $500. So you might not know that information, but we do, and we can certainly help you with that. We can also help you with preparing for child custody hearings, what needs to be included in your judgment, how to determine the date of separation, tips for calculating support, how to best deal with debts in your judgment, and how to craft an agreement that's enforceable. Your third mistake to avoid, failing to lawyer up when you really need it. 90% of divorces do not need lawyers, and 75% of cases that were filed just last year had at least one self-represented party. So we know it's possible and we know you can do it, but there's a couple circumstances in which I think you should consider lawyering up. One is if you're being accused by your spouse of abusing your children. Another is if you have a really complicated financial issue that requires an expert or complicated evidentiary rules. And then also if you're headed to a trial. Another example of when you should consider a lawyer is if you're terrified to speak in public and your case is going to court, if your spouse hired a shark attorney, or if your spouse just won't negotiate at all and is turning your divorce into a war. Quick tip, you don't have to retain a lawyer for your entire divorce. So you want to look for a lawyer who offers limited scope services, who can help you with one aspect of your divorce, but allow you to do the rest on your own. Okay, fourth mistake to avoid, not using your common sense. You want to go with your common sense and then review our resources to ensure that you're on point. So, for example, does it sound reasonable that you would pay all of childcare and pay child support? Probably not. And that's correct. Your common sense tells you what the law says, which is that if you pay child support, you likely will share add-on expenses like childcare or extracurricular expenses. Does it make sense that you would lose the $50,000 your grandmother gave you for a down payment on a house you purchased with your spouse? No, it doesn't make sense. And the law actually allows for you to get that $50,000 back before you split the remaining equity in your house. Okay, the fifth mistake to avoid, and that is relying only on lawyers and legal help. Sometimes it makes sense to spend a little bit of time with a therapist or a CPA or another tax specialist or a co-parenting counselor, someone who can help you get through a specific issue in your divorce. So don't run out and retain a bunch of people yet. We'll help you figure out when it makes sense. But some of the other people besides lawyers that can help are private mediators, forensic accountants, and friends and family. Although I would say proceed with caution because they're going to be very defensive for you and they might feel really emotional. So take what they have to say with a grain of salt. Excuse me. Okay, moving along. Let me pop back up here for a second. Okay, the sixth mistake to avoid is trusting that your spouse will be fair and cooperative. While I hope that they will be, and generally they are if they start out that way, it doesn't always go that way. And even if you trust them, they're not going to look out for you the way that you're going to look out for you. The seventh mistake to avoid is not negotiating or obtaining a child custody plan before you move out. And what I mean by that is many of our divorcing couples are still living together. Housing costs have gone up and it's quite tricky. to pay for two households in the midst of a divorce. But if you decide that you want to move out, I highly recommend you have a parenting plan in place for a couple reasons. One is that you could really lose leverage if you don't have a parenting plan worked out and your spouse ends up spending a lot more time with your children by default. If the custody issues become contested, then the court is likely, at least temporarily, to go with the status quo. And if the status quo is that your spouse has more time with your children, that's going to affect your rights with your children, and it's also going to affect child support. You also run the risk of having to file what's called an ex parte request to gain access to your children if your spouse is holding them hostage. Ex parte requests are procedural and they can be expensive. So we want to avoid that at all costs. If you find yourself needing them, feel free to book a session with one of our Hello Divorce attorneys. We have flat fees and we leverage technology to cut out a lot of our overhead. So our prices are much more affordable than other divorce attorneys with our experience level. Okay, we talked about the status quo. Let's move on to the 8th mistake to avoid. The 8th mistake to avoid is expecting justice in court. Remember, we live in a no-fault divorce state. Judges want to encourage settlement. So even if they think that one spouse is being a, quote, bad actor, they still are going to appear as neutral as possible. You might win a hearing or two, but winning doesn't necessarily mean a whole lot in family court. If your spouse is being completely unreasonable, sure, it makes sense to go to court. But if they're negotiating in good faith, or at least fairly well, then think about what your position is and choose your battle wisely. Stay out of court unless your spouse is being completely unreasonable. Just a reminder here to ask questions and be curious along the way. Consider issues like whether to sell stock or divide investment accounts, whether to buy out or divide retirement accounts. You might think, you know what, I've been contributing to my retirement account all through marriage, therefore I know my spouse has an interest, I just want to buy her out now or him out. And I want you to think really carefully about that. Coming up with a lot of cash now might be really challenging. Also, you might later regret doing that for a variety of reasons, or it might be a really good option. You might not want to share your retirement down the road, and you know that that retirement account is going to grow exponentially. So I just want you to be curious about all the different issues pertaining to property and debt and how might be the best way to resolve them. Okay, moving right along. Your 9th mistake to avoid is failing to consider long-term impact or tax ramifications of your agreement. So there are a lot of transfers and things that you can do in divorce without there being tax ramifications. For example, buying your spouse out of an asset, if you're the one that's getting the buyout, it's called a transfer incident to divorce for IRS purposes, and you don't have to pay taxes on that amount. But if you sell your house and split the proceeds, you might end up having to pay capital gains. You also might have to pay real estate commissions or staging costs, things like that. So really think about, is there any tax ramifications associated with my agreement? And if you're not sure, then talk to a CPA. 15 minutes or a half hour of their time could save you thousands of dollars. Finally, the 10th mistake to avoid, and that is choosing the most expensive lawyer. In addition to Hello Divorce, we also have a family law firm in the Bay Area where we represent people who need full representation, like for trials or hearings, and they want some help. And what I can tell you is many of our competitors charge much more money, even though they're a lot less experienced. They're not certified family law specialists, for example. To be a specialist, you have to have taken a very comprehensive exam. You have to be reviewed by your peers and judges sometimes, and you have to have had a significant amount of experience in court, in trial, and writing judgments. So just because they're the most expensive lawyer doesn't necessarily mean that they're the best. Find a lawyer that's experienced and knowledgeable and a good fit for you too. And remember, there's no one size fits all. So what might be a good lawyer for someone else, it might not be the best for you. Does your lawyer take an overly aggressive position? If so, that might be great, that if they're a great advocate and if your spouse has a shark attorney or is being completely unreasonable. But for the most part, you want a lawyer who A, is going to listen to you, and B, has a good reputation and can work with the other lawyers in the jurisdiction. That will cut down on costs and give you just an overall much more pleasant experience.